Hello, good morning. Hello, everybody. How are you? Sorry, it's been a busy day today so far. It's a busy morning, but we're here. We're ready. Jeepers, can hear. How are we? Hope you're all well out there anyway. Yeah, Trucker, good morning. It's a first for me. I'm usually late. You are usually late. I'll tell you who's not usually late, but I've not heard from her in ages. It's Kelly Eggleston. But here she is. How are we doing, Kelly? Hope you're well, my darling. I've not seen you for quite a few days now. I hope everything's well with you, my darling. Good morning, Robin G. Riding through the Glen. How are you? Hope you're well. Megan, nice to see you back here. Hello, good morning to you, my darling. Sandy, happy hump day. It is hump day, isn't it? It's going quick, isn't it? It's Wednesday. I can't believe it. What's going on, Sandy? Morning to you. Yeah, lazy. How are you, lazy? Lazy die, lazy die, lazy die. Lazy die too. Good morning, Crystal. How are you, my darling? Good morning, Dylan. I'll chat to you. I have a busy day at work, so we chat a lot. No worries, my darling. It's all good. Hope you're well. Good morning, Megan. Good morning to you, Robin G. I caught up on yesterday's stream and I have a thought. Pixie's also catching up because she sent a message. She's watching yesterday's stream as well as of now because Pixie's in Australia. So, yeah, yesterday was very interesting, I think. Lady Di, Robin G, Sandy, Kelly, yeah, good morning from Crystal. Lee says, Robin G, please do share. Robin G sent you a DM. Good morning, ma'am. Yes, share. Good day to you, sir, the King Accountant, Dennis Sweeney. How are you? Hope you are well, Mr. Sweeney. One of my favourite people is Brenda, and Dennis a little bit lower. How are you doing, Dan? Hope you're well, my friend. Now, talk about what's the word? What's the word I was looking for, Dina? Oh, I can't think of the word I was looking for. I thought I'd come into my mind, but it didn't quick enough. Morning, Dana. How are you, sir? Riff Raff. Now we've got the Riff Raff here. Dana says, hump day. So obviously, Dana, if you remember, Dana is a celebrity in Canton. Well, I think Canton, Massachusetts. He is well recognised there. So shout out to you, Dana. When I'm out there, there'll be cameras following you everywhere, probably, Dana, taking pictures. Speedo Man, he's a Speedo Man. So I don't think any of the male DNA found in the garbage matters at all. There you go. Hey, Dana. Hey, Dennis. So, yeah, we are here. I'm waiting for Kathleen, I am. I'm waiting for Kathleen. Kathleen sent me a gift. So I want to open it when Kathleen comes. Um, so we'll see. We'll see when she comes. I know it's a t-shirt, but I don't know what kind of t-shirt it is. But I'm not going to open until Kathleen is here. All the way from Boston, from Massachusetts. All the way from Massachusetts. I think Robin G must have come through the Glen and dropped it off. Hello, Pixie Medalli. I was just saying, you were also watching the medical examiner today as well because you're in Australia, mate. So you can't catch it live. That's where the live came from. That's not Australian. So when Kathleen comes, I will open this. Hopefully she. I told her to be here this morning so I can open it. So hopefully she is. Oh, yeah. It's hump day, but it's also a dull day today in the UK. I'm not sure what it's like with you guys out there, but it's very dull. It's not very good. It's one of those mood things. Oh, I got one of my cases arrived today, an orange one, which is nice. Which is good. Um, what else? Oh, shopping arrived today, so I've been busy with shopping as well. Grocery shopping that arrived today. So been quite a productive day actually today, and then we're here for another day, another dollar. Leslie, hello, my darling. How are you? Erin Hack, Erin Hack, Erin Hack, Erin Hack, Erin Hack. Erin Hack, thank you, my darling. I've just pinned it for you. Remember, people, please like the stream. Please like the stream. Thank you very much. Appreciate you. Um, It's getting hot in here for Pixie. 1 a.m. 25. Oof. Oh, no wonder you're awake. Yes. Hope you get better, Leslie. Yeah, that's too hot for me, Pixie. I couldn't do that. I don't do hot. I don't do hot. I'd rather be cold and make myself warm than to be warm and have to make myself cold. Do you know what I mean? Uh, Hit the like button or get the fuck out from Erin Hack. Hello, Sassmas. Nice to see you, my darling. I don't like being hot. I strip off then, you see, which is fine. But then you just get so hot, you get clammy, sweat. It's not sexy. So yeah, I'd rather be cold and get warm. Nothing better than I think than getting into a cold bed and just, get warm. Then there's nothing worse than getting out of a warm bed into cold, I suppose. You know, Pixie's gonna have to use my credit card to get your aircon going. I know the bills. I can imagine the aircon bills for you guys in Australia and America is huge. Do you know what I mean? I can imagine that. If you need me to read out my credit card again, people just let me know. Or if you need the security code, just let me know. Yeah. Hey, here she is, Kathleen. I've been waiting for you. I was like getting impatient now. Kathleen's like, where the fuck is she? Hello, Kathleen. Whoops. New picks, that's Matt. But before going to that, here you go. Thank you to you, Kathleen. Hey, all the way from Massachusetts. It came today. I can't wait, Kathleen. I love presents. I love presents. Here we go. Let's open it, Kathleen. I've been waiting for you before I opened it. I gotta do that because your address is on it. So I need to hide that. Then I need to. It's very sweet to Kathleen. Here we go. Oh, hang on. Before, look at how nice your handwriting is. Look at how nice. Oh, hey, that's classy. That's classy, that is. When you got that at the bottom, that's classy. You know she's classy. Kathleen's classy. I knew Kathleen's classy anyway, but now I know it because look at that. That sticker at the end. I'm going to open this first, Kathleen, before I see what you sent. That's classy. I love parcels. I love all this crap. Love it. Oh, this is nice. A card. Dylan, hope you enjoy this shirt, lol, at Kathleen. Thank you, Kathleen. I'm going to love it. I know I'm going to love it. Hang on. I am definitely going to love it. Hang on, let me put that there then. I still got Hippie Chicks Merry Christmas there. I don't do. Oh, now we know. This is Kathleen. You are so classy. It's unbelievable. Look at the bow. Look at that. Kathleen, I love this already. Loads of luck. Oh, I love this already. Look at the Irish. I love this already. Look at that. That's nice. Luck of the Irish. I'm keeping that. That is so nice. Loads of luck. I'm keeping that, Kathleen. That is gorgeous. I love that. Hey, Deb. I love that. Now, that was enough. That was enough without the shirt. Now we got the shirt. Oh, this is packed so well as well. Classy lady, you see. If this was Erin Hack, it'd be all over the fucking shop. Like, you know. Look at that. Wicked. Now, oh, look at the smell. I love it. Wicked. Ah, yes. I love it. I love it. Wicked smart. Wicked smart. I wasn't sure if I was going to say pisser or smart. It's wicked smart. 1788. Woohoo! And you know what? It's so nice as well. Hang on. It's so nice as in, ooh, ooh, ooh. I do like it. I love it. I don't like it. I love it. I do love it. Oh, where's that going? I love it so much. Let's put it on, shall we? Let's put it on. Let's get it on. Let's get it on. Let's put it on, people. Let's go. Let's go. Wicked smart. Love it. Ah, look at that. Oh, ooh. I love it. I love it. I love this. Perfect fit. It's absolutely perfect fit. Yes. Thank you so much, Kathleen. Kathleen, thank you so much. I love this. I will be doing this. I'll be taking this out to Boston. Or maybe not. I don't want to take too much stuff out with me in Boston because I want to get stuff out there. But I love it. I'm wearing this now. That can be worn tomorrow. I've got to keep that as well because that's smart. I love it. Thank you so much, Kathleen. Genuinely, thank you so much. You didn't have to, you didn't have to do anything, but I'm never going to say no because I love it. Wicked smart. Yeah, Dana don't have any of this. Dana couldn't wear this. Dana couldn't wear wicked smart. Fuck, I need to lose a bit of weight though, don't I? Do you know what I mean? The titties are getting a bit big now. Black and blue, yes. I think so. I think so. I'll put that there for now. But I do feel that, I need to lose a little bit of belly. That gives me a bit of a kickstart. But I love it. I won't lie to you, people. It's so comfortable. Like it's so comfortable. I'm not gonna lie to you. It's like the material is so nice. Look at the belly. Oh fuck! I need to lose this belly, don't I? I need to lose. I've got a couple of stone I need to lose. I need to get some motivation to lose that before Boston, so I can put it back on in Boston then. He's so nice to you, Dana. He's like, I'm not gonna shit. It's nice cotton. It's so like comfortable. It's so comfortable. Do you know what I mean? On your skin. It's not harsh or anything. Like most of my like t-shirts, and they're harsh. This is like, oh, yeah, yeah. This is nice. Chair yoga. Yeah, maybe. Does a chair yoga work? Do you know what? I do circuits every Tuesday, right? And I just get so I'm not trying to give excuses here. Right? I'm not trying to give excuses. Well, I am going to give excuses now. You have the same one, yeah, but you look better in yours, Kathleen. Let's be honest. I've seen you in yours. You look better than I do in mine. So yeah, you look very good in yours. So so once I sort my sleep apnea out, I think it's going to be better because I used to go walking every single day, or 6 days a week. But since the last year with sleep apnea, I haven't got the energy. that's why I used to fall asleep on stream all the time. I just run out of energy. So I think that's got to do with it. So I genuinely want to fix my sleep apnea. So what I have got, which I never use, is this. Oh fuck, is this. I might start using this. That's my step thing. So I can cycle. What's that, meat slicer? No, it's a biker, Grove. So I can, sorry to hear by your meat slicer. Yeah, peddling. So I'm peddling in a minute. I'm peddling. So maybe that's what I'll do, is pedal. But the trouble is, I'm fucked already. I'm tired. That's how unfit I am. But on all jokes aside, I do hope that once I get my sleep apnea sorted, that will really help me with exercise. You got to use it before it rusts. I'm using it now, then. I'm fucked. Look like a meat slicer. Big piece of meat. Court's not there yet. Well, it is, but it's no one's there, so don't worry. Does it also slice meat? I hope he doesn't slice my meat. That's all I can tell you. Fucking hell, this is hard work. This is harder than I thought it was going to be. Fucking hell. I'm out of breath. I got a treadmill, but the trouble is, then I have to lug everything up there to do the treadmill. And I always keep, my treadmill's called Wendy. I keep pounding Wendy. But the problem is, I keep falling off it as well. IBS, yeah. Cheap as creepers. Yeah, so all I want to do is lose a bit of weight before I go to Boston, so I can put the weight back on in Boston. Fuck yeah, I'm fucked. Oh, I'm tired after that. I'm gonna go for a walk tomorrow. I'm gonna go for at least 2 miles tomorrow. That's my motivation. I'm gonna go for, like, I love this t-shirt, but I feel fat in it. Do you know what I mean? If I turn to the side, you can see my belly, my tits, and my belly. I know they say cushion for the pushing, but look at Kurt. This looks like Kurt. Cushion for the pushing, but so this is a 3X, which is perfect fit for me. But I need to lose a bit of weight, so it's an even better fit. This is a 3X. I used to be 2X. Now I'm 3X. So, hey, hippie chick. Hello, my darling. Oh, thank you, Kathleen, but you're biased. You're biased. Hello, Christine. You're biased. I look smart in this. This is smart, yeah. But I got a few pounds I need to get rid of. Fucking hell, that fucking thing just fucked me over. I'm fucked. It's got dust all over it. I've never used it before. Thank you, Deb. It was great. I love this. You said it was a joke thing. I love it. I love this shirt. And I love this as well. Luck of the Irish. Best of luck. I love that as well. I love all of it. Oof. No more breath. It is consistent. This is why I'm looking forward, Pixie, to get back into the routine of walking. Genuinely, I want to get back in the routine of walking. I think people think I make it up when I say I used to walk like at least 5 days a week. And you're talking about 5 miles a day. Do you know what I mean? Now I can't even do a mile. I walked probably half a mile on Monday. Gym yesterday. But I'm low intensity in the gym. I used to be really active in it. Now I'm not. And today, done nothing except for groceries and stuff like And then yeah. Judge is around, but he's not in his gown. No, I knew you too. So probiotics, right? I looked them up. I do need to get them. Um, what do you call it? I I looked at Amazon, but I don't trust Amazon with my probiotics, so I need to get some from my next grocery shop. I do, but yeah, I will try them. I might forget what it's called, but I will try them. You have to get up and do it. Do you know what, lazy? I know you were kidding you, right? I'm not kidding you, right? I used to do it. I just don't have the energy. I get up in the morning, I eat my breakfast, I fall asleep, right? I then try and do something and I fall asleep. Then lunchtime comes around, I have a shower, eat my lunch, then I have to keep active because otherwise I fall asleep. If I go for a walk, I'll fall asleep. So that's why I fall asleep on the stream all the time. So if I do too much active and not enough sleeping, I fall asleep much more than I do already on the stream. It's a fucking curse. Boot camp. Yeah, I should do fat camp, shouldn't I? So supermarket is what we do in Pixie. My order came today and I didn't have anything else. So hey, I tell you, no way, they found the body. Oh wow, I didn't know that. Dennis, once I get my CPAP machine, I hear from Dana and everyone else that once you get your CPAP machine, you'll be back to normal. So I'm hoping I'll be back to normal after I get my CPAP machine. I generally am. Genuinely, I know people might think I'm making excuses. I hate talking about it because I feel like I'm making excuses for myself. I do, honestly, but I, yeah, I'm on my knees. I need a CPAP machine. I need me CPAP machine or something to get me going, or a good woman to kick me up the ass. That's what we need. A good woman to kick me up the ass. Let me go to see what Haxter's doing. I know, I can imagine Dennis. Dana says exactly the same. He's a new man as well. Okay. Erin Hancock. Let's do this. Whilst we're waiting for that stream, let's watch this then. This is, if you remember, the Old Miss student. This is a very bizarre case. So just so you know, the judge is there, but it's muted, and also he hasn't got his gown on. So let's do this. Yeah, put your thumbs up, people. Like the stream, please. Also, obviously, there's been a lot of news about Karen Reid overnight and stuff. I'm not ready. I've read already, but I don't 100% understand all of it. If you're not sleeping properly and getting restful sleep, it takes a toll on everything. It does. So they said to me that I've got very severe sleep apnea, and I just wake up all the time. I sleep all the time. It's really hard to explain to people. Friendly wager. It looks like it's 3,107 miles from Boston to Wales. You and I do a round trip walk daily, at least 6,214 steps per day till you get here. It's about 2.5 miles per day. I could do that. I could do that. I probably would be aiming for more than that though. But yeah, I could do that. That would give me motivation, Dana. That would help me. That would help me. That would really help me. Let's look into that then. Let's do it. Let's do it. Let's do it. Fine, I like the idea, Dana. For one, well done, Tracy, for thinking of the idea. So, round of applause for Tracy for thinking of the idea. I'm joking, Dana. That's a class idea. Let's get our heads together on that. Absolutely. Let's start it. Let's look to start that in the coming days. He's going to have to swim to get to America. I like that. I'm going to start that. Morning, Patty. Lana's live now about it. Yeah, so Lana does good stuff around covering documents and stuff like that. And Lazy is one of her mods. So yeah, I mean, go check her out afterwards. That's good, isn't it? It's good, Pixie. You better, or you get no tips or carrot cake. No, Joe, that is it. Fine. That's it. Fine. I will. I also, what I'll do is I'll weigh myself and see how much I can lose on top of it as well. I'll walk it with Dana, and I will. I'll be held accountable every day. You know, and I have to walk every single day. As Dana says, minimum was like 6,000 something. What I might try and do is balance it in a week or something. I'm not sure, but yeah, and I'll try and lose weight from that way, so I can get Brenda's carrot cake then. There you go. Swimming is a great way to exercise as well. Yes, Dylan's so smart. No matter what Dylan says, he knows I love him. Don't tell Carrot, that's the best. I can't wait to Brenda's carrot cake. Great idea. Hey folks. Hey Vic, how are you doing, my darling? Charity's one of Lana's, but Charity's. I don't know. I need to get in touch with Charity. I don't know if I've offended Charity. I don't know, because she never comes in here anymore. And I love Charity, so I don't know. I hope I haven't offended her or anything like that. Thank you, Leslie. Thank you, my darling. Right, let's watch this then, and then yeah, Dana, we're gonna get our heads together. I mean these heads, not the Here we go. This is the Ole Miss trial until we wait for the other one to start.
The remains of missing Ole Miss graduate Jimmy J. Lee have been found nearly 3 years after his disappearance sent shockwaves through the community. This comes just weeks after a mistrial was declared for the accused killer, who had argued that without a body, there was no case. But now everything has changed. I'll take you through the latest developments. For Law and Crime News, I'm Kennedy Walker. He had just texted his mom happy birthday, a simple message that would end up being the last anyone heard from 20-year-old Jay Lee. Hours later, he vanished. Prosecutors argue that Jay was lured to his death by Sheldon Timothy Harrington, a man he had a sexual relationship with. But there was one major problem. Police could not find his body. Harrington denied killing Jay, and his defense team argued that without a body, how could he possibly be charged with murder? The jury was deadlocked and the judge declared a mistrial, but now the very evidence Harrington's defense claimed didn't exist has finally been uncovered. This case dates back to July 2022. Jay had recently graduated from the University of Mississippi, commonly known as Ole Miss, that spring. He was known for his active role in Oxford's LGBTQ+ community and his involvement as a local drag queen. On the morning of July 8th, police say Jay went missing, wearing only gray slippers, a silver robe, and a gold bonnet. His mother, Stephanie, said Jay had texted her earlier that morning, wishing her a happy birthday. But when she didn't hear from him later that day, she testified she knew something was wrong.
That was my birthday, and Jay would call me every year on my birthday to sing happy birthday, no matter what time it was.
Stephanie said she and her husband had gone out of town to celebrate, but as the hours passed with no word from Jay, her concern started to grow.
I just told my husband, I said, I hadn't heard from Jay. This is not normal. I said, Jay would call, and which my husband knows already too. He said, that's strange. He ain't called. I said, yes, he had to call. I hadn't heard from the early on text. And I was just worried the whole trip down there. So we proceeded to go on down there. And we got to our destination, and I just continued to try and call Jay periodically throughout the day and didn't get a response.
Stephanie's motherly intuition was telling her something was wrong. So she and her husband cut their vacation short, drove back the next day to check on Jay, and called the police.
That I made a number of calls to Oxford PD doing wellness check. I called periodically the day of July 8th, probably 9-10 times, maybe more, I'm not sure, but I kept calling and telling them that I needed them to go and do a wellness check with my baby.
Then she noticed Jay's location was turned off. She says she immediately reached out to Jay's friends, hoping someone would know where he was.
I knew that he communicated with Jose. So I reached out to my oldest child and I said, can you communicate with Jose? Can you find his number on Instagram or somewhere so maybe he can go over to the apartment to see if he see Jay car or something, what's going on, because they can't contact Jay. So in the process of this, Taylor communicated with Jose. Jose went over to the apartment and he communicated back with us and said, well, Mama Lee, I hear the dog in the house. I hear Lexus there. And Jay wouldn't leave Lexus too often because Jay take Lexus everywhere he go. And I hear the dog in the apartment, but I don't see Jay's car.
Now Stephanie is starting to panic. She and her husband rush to Jay's apartment, but when they get there, he's nowhere to be found. So she called the police again. The search quickly ramped up, with authorities eventually finding Lee's car at a local towing agency. For weeks, they scoured the area for any sign of his body, but could not find him. Then on July 22nd, they made an arrest. Sheldon Timothy Harrington was taken into custody and charged with Jay's murder. Both men had attended the same university, but what was the connection between them? And how did they know each other? Well, the prosecution laid it all out. Sergeant Benjamin Douglas with the University of Mississippi Police Department took the stand and walked through the social media and Google records that investigators say placed Lee at Harrington's apartment on the day he disappeared.
But we were able to see the messages that Jay Lee had received. In those messages, we found texts in the time frame that Jay Lee had left his apartment that sounded as though he was going to meet somebody that he had already met. Messages like, come back.
According to court documents, Harrington messaged Jay saying, come back in the early morning hours of July 8th, the same day Jay went missing. Prosecutors say that Jay had blocked Harrington on Snapchat after falling out that same morning. But that did not stop Harrington. The defendant allegedly reached out to Lee from a different Snapchat account that Lee didn't recognize. Police then obtained another search warrant, this time for Harrington's Snapchat messages. His account, Red Eye 24, was examined. And here's what Sergeant Douglas testified was found.
So it's Jay Lee, he says, who is this? And then he sends a question mark. He then sends, what did you do?
Into the microphone.
What did you just delete? He then sends, Jay Lee then sends, you made it like this. Red Eye responds, come back at 5:25:26 a.m.
And the next message, who is that?
Harrington sends, you coming or nah at 5:26:54 a.m.
Continue on, please.
Lee then says no at 5:27. Harrington asks why not. Harrington then sends 2 question marks
At what time?
at 5:31:43 a.m.
The conversation then revealed details of a recent sexual encounter between the two men. And in one message, Jay even mentioned Harrington by name.
Jay Lee, he says, like you done did some questionable but that was too much. Jay Lee then says, have a good night, Tim.
That simple mention was a crucial confirmation that Tim Harrington was the person Jay had been speaking to.
The next message is from Jay Lee, and it says, yeah, now it seems like you just trying to lure me over there to beat my or something.
What about the next? And what time was that sent?
That was sent at 5:37:16 a.m.
What about the next?
The next was sent from Red Eye, which is Tim Harrington, and says, "You tripping. I do feel bad because we cool. I ain't trying to end it like this."
Continue on, please.
The next is from Jay Lee, and it says, how we cool, and you barely want me to text you.
You can please tell me the timestamps as well.
That was sent at 5:39:10 a.m. The next was Harrington. It says, I'm saying you're a cool person at 5:39:54 a.m.
The messages continue, detailing their alleged sexual relationship, and Jay eventually agreed to meet Harrington at his apartment. Records show that less than 5 minutes after Jay agreed to meet, Harrington Googled, "How long does it take to strangle someone?" Gabby Petito. You may recall Gabby Petito was tragically killed by her fiance when they were traveling together on a cross-country road trip. The prosecution later called a Walmart employee who testified that Harrington purchased a roll of duct tape that same day, and he even presented the receipt in court. Surveillance video captured the moment Jay arrived at the defendant's apartment. It was the last time anyone saw Jay Lee alive. A few minutes later, security footage shows a man believed to be Harrington running away from the Molly Bars Trails apartment complex. We would later learn that Jay's car was towed from that apartment complex, and police discovered it a couple days after his family reported him missing. Cameras from a nearby gas station captured the same man who was seen running earlier. He got into a white Kia Optima, and the driver quickly took off. The driver later identified Harrington to police. During the course of the trial, more information came out, including the fact that Harrington was not openly gay to his friends and family. Harrington's father testified that he didn't know his son was interested in men until Timothy was arrested.
And were you aware that Timothy had an interest in men?
No,
Today, are you aware that he has an interest in men?
by the proceedings, yes.
And so back in 2022, were you aware that he had an interest in men?
Other than the reports that came out.
So after the reports came out is when you discovered that?
Yes.
So he was not open with you about that?
No.
Is that something that your church approves of?
Not necessarily the church approves of. I think that with that, people have their own opinions.
At this point, it was clear the prosecution was attempting to build a case suggesting Harrington may have killed Jay to avoid being exposed to his friends and family as gay. They used surveillance footage to establish a timeline of Harrington's whereabouts, highlighting gaps where he could have disposed of Jay's body.
Family and his friends about his sexuality, being on the down low, they all thought he was into women. But we know there was a secret that he was keeping in his life. He lied to them, he lied to his church, his family, his friends. He lied to Jay Lee to get him over that night because he had a problem that he had to fix. Then he lied to the police about everything. Deception, lies. He had to protect that lie. And what did he do to protect that lie? In order to protect that lie, he had to get rid of jail.
Next, the prosecution revealed that Harrington, who was part owner of a moving company, had allegedly taken the company's box truck for the day. However, he did not inform his business partner that he would be using the truck.
And did you and Tim have any moves scheduled that day?
None.
And usually, did you both know if you had moves scheduled?
Yes,
And who had keys to the box truck?
we both had a key.
So did anyone else have a key?
No.
So just you and Tim had keys?
Yes.
Surveillance footage shows Harrington allegedly driving the white box truck to his parents' home in Grenada, Mississippi, making 2 trips. On the first trip, he brought a full-size shovel, and on the second, a wheelbarrow. But despite the prosecution's case, defense attorney Kevin Horan argued that there was no proof Jay was murdered since his body still had not been found. Harrington faced life in prison for Jay Lee's murder. The jury deliberated for more than 9 hours, but they couldn't reach a verdict. They were deadlocked. After 3 attempts to come up with a verdict, the judge declared a mistrial.
I'm gonna declare a mistrial.
That mistrial happened in December of 2024. Now, less than 2 months later, everything has changed. Authorities confirmed that hunters found the remains of Jay Lee in Carroll County, Mississippi, ending the nearly 3-year search for his body. According to Mississippi Today, the remains included a gold necklace with Jay's name on it. So the big question on everyone's mind, now that his body has been found, what's next for Jay's accused killer, Timothy Harrington? Well, back in December, the prosecution said they'd be interested in retrying the case. And now with this new evidence, they could have a whole new opportunity to try him again. For Law and Crime, I'm Kennedy Walker.
Oh, that'll be interesting. That will be very interesting what comes out of that. Thank you, Haxter. Haxter's done well there. And whilst we're on here, let's have a look at the Shanna Gardner one. This is the update on the Microsoft exec. Might as well do this. We can zoom the other one if it started anyway, can't we? There we are, right. Present. So for those of you who don't know, this is the Microsoft exec. His ex-wife and her husband at the time are accused of killing him with his little child in the car at the same time. So we'll cover it now so you can see. But Sass is blushing. What are you blushing for, Sass? What have they done now?
I told the state that I thought I suspected that there may be an inmate in the jail who was influencing Mr. Tennant, and that it could have been that a co-defendant had gotten to him. That's my suggestion.
Do you have information that's true?
Jared Bridigan. This is in Florida. Lazy.
You know, was that just speculation of you doing this kind of work for decades?
It was me trying to figure out why my client had surprised me in court.
The alleged hitman at the center of what police in Florida are calling a sinister murder-for-hire plot may have just said in open court that his testimony was false. Now, the attorneys for the people accused of hiring him are crying foul, saying the court needs to investigate what exactly this accused hitman meant and whether that has any impact on their clients' cases. We are going to dig into the latest court motions and hearings in the killing of Jared Bridigan. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Henry Tennant, now 64 years old, allegedly admitted to police that he killed Jared Bridigan, a Florida Microsoft executive, back in 2022. But now, it seems he is trying to say things didn't happen the way police believe, which has put an entirely unpredictable wrench in this story. Because let's go back to this. We have 33-year-old father Jared Bridigan, really sad case, just dropped off his twins that he shared with his ex-wife Shanna Gardner at her home in Jacksonville Beach on February 16, 2022. He was on his way home with his daughter from his current marriage in the backseat of the SUV when he comes across a tire in the road. This is according to authorities. So he allegedly gets out to move the tire, and that is when he's gunned down, shot multiple times, left for dead in the road. People driving by spotted him, called 911. Police paperwork states, quote, other than the murderer and the victim, the only other witness to the murder was Bridigan's 2-year-old daughter, who told Child Protection Team investigators that a man came up to the car, she heard boom, 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 and then Daddy hit the ground. How heartbreaking is that? Now, without context, Bridigan's murder appears to be completely random. He wasn't armed. There's no evidence of a struggle. His belongings, like his wristwatch, his wedding ring, his phone, his money, his wallet, none of that was taken. His truck wasn't stolen. Bridigan's daughter was unharmed. But this brazen murder, maybe not surprisingly, made headlines all over the country. And then Bridigan's current wife, Kirsten, reportedly encouraged police to look into Bridigan's ex, Shanna Gardner, and her new husband, Mario Fernandez Saldana. This is according to reporting from local affiliate WJAX. So going back to Henry Tenen, according to authorities, he was a tenant in a property owned by Fernandez Saldana. Now you're starting to see the connection. And investigators believe Fernandez Saldana hired Tenen to commit the murder, allegedly using money from Gardner's trust fund account. And police say Tenen's truck was seen on surveillance video, security video, near the crime scene around when Bridegan was ambushed. They got a warrant for his bank and phone records, discovering that Tenen and Fernandez Saldana apparently communicated 35 times in February. Authorities also say Fernandez Saldana wrote 3 checks to Tenen months after the killing. Tell me a story like this doesn't just scare you about the world, right? And I'll tell you what, we try to partner with sponsors who can maybe offer a little bit of protection to your lives. So with that in mind, let me tell you about Delete Me. I don't know if you know this, but apparently your personal data is talking about his DUIs and revoked license to get him into an list of 2022. Turns out he's a habitual traffic offender, wasn't even supposed to be driving. So police arrest him, and they use the ruse of talking to him about his DUIs and revoked license to get him into an interrogation room. And that's when this happens.
You do not have to make a statement or say anything. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before you make a statement or before any questions are asked of you, and to have the lawyer with you during any questioning.
So the detectives show Tenen pictures of him driving all over town in different vehicles with pictures snapped by license plate readers and other cameras.
So the car you're driving today, it was a Crown Vic, is that right? Mm-hmm. Same car you were in the other day when you were involved in the little fender bender? Correct. So I read the report on the fender bender, and it looked like you just made a mistake, kind of said, hey, I got nervous, drove off. I'm guessing.
Actually, I don't know what happened. I panicked. Okay. I'm like, oh man, what? And I went around the block, stopped, and sure enough,
because you knew the police were coming, right?
Yeah.
Yeah.
So I just stopped and just chilled out from right there. I thought I got my senses back together. Just waited. I said, oh, I'm going to jail.
Because you knew
they're gonna put you in impound.
Because you knew about your license, you shouldn't be driving. So you know that I know the answer to most of these questions I'm going to ask you. I'm trying to see what kind of man you are. If you're a man of character, and you're going to be straight with me, okay? Because I'm willing to work with those kind of people and willing to have a discussion with them about how we move forward.
And then the detectives also asked Tenen about a trip he took, or apparently took, to a tire shop. And police reports indicate that a tire matching the one in the road when Bridegan was shot was found at the home that Tenen was renting from Fernandez Saldana. But it seems that Tenen tries to deflect.
You did something to the truck. You had to get something on it. You remember what it was? You went somewhere and bought a couple. That should tell you where you were with the truck. Tires, get tires.
I went out there to
value tires, something like that, discount tire. Yeah. Get a couple tires put on it.
Mm-hmm.
You get flat or something?
No, it's just what?
Oh, okay.
After more than an hour of talking, the detectives start to let on that this is about more than just some traffic violations.
All right, Henry. So here's what's up. Today's the most important day of your life. All right, I'm gonna shoot you straight. You got tough decisions to make, but there's really only one right answer. So we've told you a lot, but we haven't told you everything. And you've been pretty honest with us, and I appreciate that. But there's a lot more to this than what we've told you, what we've let on. So there's other people down here that we're interviewing at the same time about a case. It's way bigger than some traffic charges.
Yeah, I don't figure that much out already.
Okay,
I just don't know what.
Okay, well, you're going to know in a second. And these people, so this is a choice you get to make. You're at what they call a crossroads in your life, okay? There's two paths you can take. One goes this way, one goes this way. One can lead to Henry still being Henry, out living a life potentially one day, because we know what Henry's all about. And he's not somebody that's going around doing violent things, doing vicious things to people. But somehow Henry got caught up in something. You got put in the middle of something, and now it's spiraling out of control because these other people involved, because this is your vehicle involved that you're in, are going to point the finger at you. And they've already started to do that because no one wants to go to prison for the rest of their life. Nobody.
Now, parts of the interrogation are redacted or muted, so we don't know everything that Mr. Tenen said, but detectives did indicate they wanted to help him if they could.
But guess what we can't control? What's next?
Every day.
That's what we get to control, Henry. What's next? How am I remembered? How do I want to go out of this world? A man of character, a man who did what's right, or just some chump? Because that's what we're being played for right now, is chumps. We ain't no chumps, Henry. I know you ain't no chump. When I said respect, I meant it. I give you the same respect you give me. You've been respectful to me. I haven't raised my voice at you, and you raised your voice at me. We've disagreed. We know we're not on the same page, but we both know we can get there.
So Tenen was in that interrogation room for reportedly 5 hours before he asked for an attorney and was taken to jail. And several months later, he was officially charged with murder in the second degree, conspiracy to commit murder, accessory after the fact, and child abuse, because Bridegan's young daughter was a witness to her own father's murder. She was there when this happened, this violent crime. Now, with respect to Fernandez, Saldana, and Gardner, they face first-degree murder, solicitation, conspiracy, and child abuse charges themselves. Fernandez Saldana was arrested first, then Gardner was arrested in Washington State because that's apparently where she moved with her children. She was extradited back to Florida. They were both denied bail. And we told you recently here on Sidebar, despite petitions from Bridegan's parents to gain custody of their grandchildren, that was actually denied, and Gardner's parents were given custodial rights. So going back to Tenen, he entered a plea agreement. Pleaded guilty to one charge of murder in the second degree, according to court records. Prosecutors say he agreed to testify against Fernandez Saldana, and Tenen would be sentenced after his co-defendants go to trial, and according to his plea agreement, he'll spend between 15 years to life in prison as a result of this. Or I should say, will he? Because that might be up in the air right now after some comments that Tenen apparently made at a recent court hearing. So news of a possible about-face exploded in the news last week when Gardner and Fernandez Saldana's defense attorneys got a look at a transcript from a recent court appearance by Henry Tenen. It was a simple status conference where the judge and the attorneys make sure everyone's on the same page and the case is on track. But during that hearing, Tenen wasn't really supposed to speak, but he ended up addressing the court, managing to say that the testimony he'd given wasn't true. Now, this is apparently before the judge and Tenen's public defender had to quiet him down. Now, of course, when the defense attorneys for Tenen's co-defendants heard about this, they wanted more details. So they filed a motion with the Duval County Court that reads, quote, on March 15, 2023, Mr. Tenen provided a sworn statement in which he implicated Mr. Fernandez in the crimes for which he's been charged in this case. As of the filing of this motion, the March 15, 2023 sworn statement is the only testimony that has been made by Mr. Tenen and provided to the defense. On February 4, 2025, the defense received an email from the state that contained a hyperlink to additional discovery. Upon downloading the material, defense counsel discovered the transcript of proceedings status hearing for State v. Henry Tenen on January 13, 2025. As contained in the attached transcript, Mr. Tenen, in no uncertain terms, informed the court that he wanted to bring the court's attention that his prior testimony was, quote, false testimony. Mr. Tenen goes on to request another attorney. No further action is taken by the court regarding this request by Mr. Tenen. The court addressed Mr. Tenen and told him that his case would be temporarily passed and he could speak with his lawyer in private, and the court will then have another conversation with Mr. Tenen. The court asked Mr. Tenen if that would be okay with him, and Mr. Tenen responded, okay. The defense continues. Inexplicably, Mr. Tenen is never brought back out to the courtroom. He is never able to address the court, and his case is passed until January 22nd, 2025. On January 15, 2025, per an email from Judge Kite's judicial assistant, Mr. Tenen's case is passed nearly 3 months to April 14, 2025, meaning Mr. Tenen will not appear or have an opportunity to address the court for over 3 months since the time he informed the court he provided, quote, false testimony. Since the time Mr. Tenen has indicated that he has given false testimony, it has been over 3 weeks, and other than the transcript of the proceedings, the defense has been provided with no additional information. So let's take a look at that transcript from the court reporter at the quick hearing back in January, because it's pretty interesting. So Alan Chipperfield is Tenen's public defender. And in the transcript, he says, quote, good morning, Your Honor. Alan Chipperfield for Mr. Tenen. Your Honor, I think we just need a pass date. The court responds, I was just checking in because I hadn't seen Mr. Tenen since last year. I was just making sure everything was okay. Mr. Chipperfield responds, I think he's doing okay. The court says, okay. And then Mr. Tenen says, Your Honor, may I say something? So the court responds, talk to Mr. Chipperfield first. Tell him what you want to tell me, okay? And then Mr. Tennant responds, I just want to bring your attention, my testimony. And the court says, no, 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 no. Mr. Tennant says, false testimony. The court says, hold on. Mr. Chipperfield jumps in, says, Mr. Tennant, we need to talk about that. Mr. Tennant says, I need another attorney. The court says, okay, let me pass it temporarily, have a conversation with Mr. Chipperfield, and then I'll have a conversation with you, Mr. Tennant, okay? And Mr. Tennant responds, okay. Now, as the defense said, Tennant doesn't end up coming back into the courtroom that day. And the following day, the court gets an email from his attorney, Mr. Chipperfield, that says, we have resolved the issue raised in court yesterday after a meeting with Mr. Tennant. Both parties request that the case be removed from the January 22nd calendar and set at least 60 days out for a pretrial. We don't expect there to be any action in the case until the co-defendants take Mr. Tennant's deposition. So if that's true that this issue has been resolved, don't quite know what that conversation was with his attorney. We will not know. It's attorney-client privilege, but that's an interesting about face in multiple ways. So the defense attorneys for Gardner and Fernandez Saldana, they were understandably miffed by this latest development. I mean, the key witness now doing an about face. And they believe that there should have been communication from the court about Tennant's apparent statement. So they demanded a hearing where one of the attorneys actually questioned Chipperfield about what happened.
Would you agree that you're a meticulous note taker?
Yes.
Do you have notes that reflect these conversations that you've talked about with the state and with the court?
Yes.
Did you review those notes before you came to court?
Yes, and I have them with me.
Okay. What, to your recollection, do you recall, other than telling the state that it could not be resolved today and that you wanted to pass it, what did you say specifically as to any more detail, and what is your recollection or notes as to their response or any other commentary they may have made to you?
I suggested that we have a meeting and not bring him back into court, pass the case. I told the state that I thought I suspected that there may be an inmate in the jail who was influencing Mr. Tennant, and that it could have been that a co-defendant had gotten to him. That's my suggestion.
Do you have information that's true?
No.
Was that just speculation of you doing this kind of work for decades?
It was me trying to figure out why my client had surprised me in court.
Because you brought it up, do you have any information now that your client was influenced?
No.
And at times, things got a little heated in that courtroom because each party, including the judge, appeared insulted at the idea that there could have been some kind of misconduct on their part.
What is the state?
The only thing I would suggest, and I will just make it part of the record.
asking you, Mr. Judge.
Well,
Can I?
yeah, sure.
Okay, what is it? Does the state want to respond to this, or do you need additional time?
We need no additional time to respond, Your Honor, other than I guess to inquire if the defense wants the actual email to our investigators bringing Mr. Tennant over to our office. Mr. Chipperfield has already indicated there was a meeting in our office. There was a meeting in our office. We have nothing else to disclose as to those paragraphs, other than there was probably an email ordering him from the jail over to our office on I think it's the 14th, the next day. And so we would, obviously it's proper for lawyers to talk to witnesses. That's an entirely proper thing, and normally not something that's discoverable, although based on everything, the state has no objection to discovering the fact that we did talk to Mr. Tennant and Mr. Chipperfield already testified to it. That's not an issue.
Okay.
There's nothing else that the state is discovering at this time.
All right.
So the defense is seeking various pieces of information, including any communication that might indicate what Tennant meant by false testimony and if he could have been influenced by anyone inside or outside of that jail. A court appearance is actually scheduled for Wednesday. We're keeping an eye on that. But for now, Tennant's next status hearing is scheduled for April. Fernandez, Saldana, and Gardner are set to go to trial in October of this year. We'll see if that court date sticks. And I should tell you this, they face the death penalty if they're convicted. That's all we have for you right now here on Sidebar, everybody. Thank you so much for.
It's all going on. It just like shows you the corruption everywhere at the minute. Thank you to Vix Vix, my darling, thank you so much to you for the coffee. Have a lovely day. Thank you, Vix. I appreciate you. Thank you, my darling, for the coffee. And obviously, shout out to you, Leslie. Thank you for the two $9.99 stickers as well. Thank you, my darling. And to the dogs as well. Thank you, everybody. There you go. Right, we'll go back to court now itself to see what's happening. Is it caught back or is it not? It wasn't. I hadn't started. No. Oh, short break. Hang on. So they did start, and then they now want a break. So let's go back here then. There's a bit we can watch here before the break. Let's go here then. Right. And for those that missed it, thank you so much again to Kathleen for the wicked smart. Wicked smart. I love it. Kathleen Liakos, thank you, my darling. It's a short break. It might be something, I don't know. I don't know. We'll see. We'll watch it together, Heather. We'll watch it together. So we'll see. Right. So the defendant is in. And we'll see. Let's zoom a little bit.
But I've changed it on the original. So yesterday, the state indicated they may have another witness or at least exhibits.
Boosted for depth.
There might be an objection to whatever the exhibit is.
Yes.
So I thought we'd take that up before I brought the jury in. So
Seahawk.
Yesterday, the state indicated they may have another witness or at least exhibits. And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes.
So I thought we'd take that up before I brought the jury in and had to send it back out.
Yes, Judge. The state intends to introduce a certified copy of the order from the Circuit Court in Bristol, Virginia, which ordered Hunter Wood involuntarily committed to the mental hospital over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a letter dated January 10th, 2025, which is from the Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the Circuit Court of Bristol, Virginia.
We have no objection, Judge.
Okay. So what I intend to do, and then after that, do you think you'll have any proof?
No, Your Honor.
So what I'll do is I'll bring the jury in, admit that in the next number of exhibit. Then you can rest in front of the jury. And then I'll have to send them back out so we can take up some matters out of the presence. All right, we bring jury in.
So that's why if you sent out, because the state arresting. Okay, they're arresting. Okay. Cork Island, Leslie, if you can get out to Ireland, it's a beautiful place, beautiful country. I can't wait to go to Dublin myself in April. I lived there for nearly 2 years. It's a gorgeous place. Cork, I've never been, but Cork's a bit rough and ready. In some ways, like similar to Boston, I think, where people just tell you what you think to your face. They're like wicked pisser. So yeah, little things like that. So yeah. So state arrested then, which is good. So obviously the things that they need to do with after this is the motion to dismiss and stuff like that then. So
Do that. Ladies and gentlemen,
You may be seated. Thank you.
all right, Jen, I'll call your name. Oh, wait, before we do that. Ladies and gentlemen, yesterday when we left, I gave you certain admonitions. Do any of the jurors have anything to report with regard to those admonitions? If you do, raise your hand. Let the record reflect that none of the jurors raised their hand. All right, John.
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the circuit court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. If we would offer that as the next exhibit in this case. 261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit 261. All right, call your next.
Judge, the state would rest.
All right, ladies and gentlemen, I know you've only been out here for 2.5 minutes, but I'm going to send you with the officer.
Everyone stand, please.
lazy, no one is talking about your vagina. There's lazy. No one's talking about your vagina. So I'm not sure. Right. Let's see the motion to dismiss and stuff like that now, and then we'll go from there.
You may be seated. Thank you.
Mr. Scott, you have a motion?
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts. Just briefly, I'll go through them. As it relates to the first 3 homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various, although she stated that she believed it was asphyxia, she later under cross-examination admitted it could have been a SIDS death. She admitted it could have been a heart issue, or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count 1 in premeditation, there is no evidence whatsoever in this case of premeditation. So those are the 3 murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect its health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion. False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those, but I will leave those for now, but I do move for a judgment of acquittal without further argument. And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
I'll be brief, Judge. Of course, the court reviews this motion in the viewing the evidence in the light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket, and then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation is at least shown through the physical evidence in this case. As far as the remaining counts showing the cause of death, both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
All right. Of course, as Mr. Scott and the general has stated, in viewing the evidence in light of the Rule 29 motion for judgment of acquittal, the court's required to view the evidence in the light most positive to the state. And looking at these charges and the proof through that lens, with regard to count one, the premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, you couple that with the voluminous amount of evidence where the defendant was given different stories as to where the child was, as to how the child was doing. When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that day, it was story after story about where the child was. The defendant appeared to have moved on to other things. And I think when you take all that evidence and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But the course of the opinion the state, when looking at that proof in the light most favorable to the state, that they had put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think that taking in the light most favorable to the state, the fact that that child was wrapped and placed in the garbage can. I think the jury can look at that. And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy, dirty toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. I think that taking the light most favorable to the state, that those two counts would survive the Rule 29 motion, and I'm going to deny the motion with regard to those two counts. With regard to the tampering with evidence and false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in the light most favorable to the state, I think those are issues the jury can determine and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right. In that case, we have to go through the Loman versus State questioning. And I'm going to hand this down and let you do that.
Judge, for the purpose of the record, would you like her to come to the?
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Scott.
Megan, I want to ask you some questions about my representation of you and explaining to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes.
Okay. And part of that, I've talked to you about, you have the right to testify. Is that right?
Yes.
And if the jury can't hold it against you if you don't testify, do you understand that?
Yes.
Do you understand you have a right not to testify?
Yes.
Okay. And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
Yes.
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
Yes, I have.
Do you want to testify?
No.
I think I covered it, Judge. Approach.
Yeah. All right. We got other proof?
No.
No. I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest.
No.
No.
What? The trial's over. They're not putting any witnesses on. The defense are not putting any witnesses on. That we're going into closing arguments. So she's not testifying, and they have no witnesses. The fuck?
All right. Will you have other proof?
No.
No. I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I got to send the jury out so we can finalize the charge and give the parties time. Because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them nod off if they're reading with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we'll bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I will finalize it and send it out. That's the process going forward. And during this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for closing argument. Okay? So we need to bring the jury. Committed to do a moment ago. Yesterday, during Dr. Malushnik, did I say that right?
Yes, sir.
At the very end of her testimony, she answered a question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? Yes, sir. I'm going to instruct you that last phrase, you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Everybody puts that murder in some other way out of their mind and not consider. If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Been at rest.
All right. Ladies and gentlemen, where we are now is the proof is closed, but it is not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow along, and you'll have that for your reference while you deliberate. Okay. This will also, and what will happen is it'll probably take 45 minutes to an hour. I'll get all the notebooks made. We'll give the lawyers time to organize their thoughts for closing. When we come back, I will hand out the notebooks and I will read you the charge, which will be painful, and I apologize for that, but that's the way it is. And then we'll go straight into argument. Okay? So I apologize for the length of the break, but just bear with me. It's necessary. Okay? You'll go with the officer.
Everyone stand, please.
All right, we'll be in recess. We'll probably take 45 minutes.
Court stands in recess.
So they're going to take 45 minutes to an hour recess. So the judge is going to finalize his jury instructions, and then we will have closing arguments after that then. So yeah, let's go through this. But also what you need to remember, I see some people saying guilty, but what you got to remember is there's 19 counts. Is she going to be found? I think she probably will be found guilty on probably all 19. I imagine. I don't think there's a question in most of them. They're like simple. It's just when you come down to like the mishandling of a corpse and stuff like that. I'm not sure if they've done enough on that one. Depends on the argument from the defense. I don't know. There's a few of them. I don't think they're slam dunk guilties. I think there's a few they will be deliberating. I think the murder charges they will get that done pretty quickly. But then there's probably 3 or 4 that are a little bit more complicated to look at. Music is the court. I'll switch it off. That was the court. So, oof, I did not expect this. I expected, well, it said 3 weeks. I mean, I think they think deliberations will take a long time. So, I don't think it's going to take that long. As I say, personally, I think there's probably 3 or 4 charges that they will need to discuss in depth, and the rest will be pretty simple. Probably, Katie, probably, you're right. So, yeah, so I think they're coming back in about half an hour with the, what do you call it? Jury instructions. Jury instructions are going to be at least, he said, at least 77 pages. So that's going to take a long time, you know, or well, probably an hour and a half minimum to read all that. So the charges will take, yeah, at least an hour and a half. And then I'm not sure how long closing arguments are going to be. He hasn't stated that yet, so we'll have to see. I think a lot of the how quick it's going to be is, I think it depends on the jury. I think a lot of it's going to be dependent on what type of people they are. If they're like, if you've got organised people, they probably want to reread the whole charges again as well for themselves. So that's what probably will take time. It may not. You know, I think for me, I wouldn't want to read the charges again unless there was 1 or 2 that I wasn't sure of. I would just be like, yeah, bam, 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 bam. But then there's some people that are, you know, will want to know. I want to reread everything again, and the sticklers. But we don't know what the makeup is of the jury, so we don't know what type of people we got in there. So I don't think there's going to be a right or wrong answer whether how quick it's going to be. If it was just like a 3-4 charges, I think we would probably get a guilty verdict in less than half an hour. But with so many charges, I'm not sure. Hopefully it's quick. Hopefully it's quick. I think it's quite self-explanatory. So we'll see. Right. What else we got here? If I'd known all this, I'd have fucking kept the other stuff until now. Erin, hack. Ole. Let me put that down. So, because it's requested as well, they're going to be deliberating all night long, all night. Possibly. I presume they could be. We're going to have. I presume we're going to have a verdict today. Oh, we're going to have a verdict today. You think another CG thinks 20 minutes per charge, so that would be roughly nearly 7 hours. You think another CG? I don't think it'd be that long, personally. I don't think it'd be 7 hours. I think at the tops, I personally think you look at tops about 3 to 4 hours tops, I think. And that's with people that are sticklers, like, you know, wanting to reread it. But if you haven't got any of those people, I think it's like less than 2 hours. So we'll see. We'll see. I think a lot of the charges, I would say, the CG are very similar. They're basically the same, just worded slightly different. Like That's why I think some of them will be super quick to go through. But then if there's a couple they're stuck on, then you could well be taking longer. So we'll see. That's the interesting thing. We just don't know. Right. Fuck. Let's have a look here. Right, hang on then. Let me just find something here. Wicked smart. I love this. Oh, hang on. Robin G. She's riding through the glen. Hang on. Where's Robin G? Let me stop chasing all the men, Robin G, and let's do this. Robin G, riding through the glen. Robin G, chasing all the men. Robin G's in trouble here. Look what Robin G did. Hang on. Hang on. Shit. Robin G, chasing all the men. Oh, right, it's 3.5 minutes long. Robin G sent me a video. Chase those men, Robin G, chase those men. Right, so this is the ex-boyfriend of Megan Boswell. His interview, which we will play here now. Robin G sent it to me last night, so let's play it here. Boost for Deb, yeah, boosted.
The FBI, state and local investigators are teaming up tonight to try to find a 15-month-old little girl from Sullivan County. She's believed to have been last seen a couple of months ago.
That case is making headlines across Tennessee and the country. One day ago, the Sullivan County Sheriff's Office said a missing child investigation was underway for 15-month-old Evelyn Boswell. Investigators said she was last seen by some family members the day after Christmas.
Around 8 o'clock last night, things escalated quickly. The TBI issued an Amber Alert, and it is still unclear why the child was reported missing after she was last seen several months ago, or a couple of months ago. Tonight, the National Center for Exploited and Missing Children issued its own plea for information to try to track down this little girl. Febin Casahoon's live at the Sullivan County Sheriff's Office, where she's been monitoring developments in the case all day. Febin?
Now, as the investigation continues for the search of this 15-month-old child, many people are telling me that they are being attacked on social media due to their involvement with the family. And I spoke with one man who says he has nothing to do with the disappearance of 15-month-old Evelyn Boswell.
I've never seen the baby in my life.
Hunter Wood says he briefly dated Evelyn's mother, Megan Boswell.
She applied for a job at my restaurant, Hunter T's Chicken Shack, and it wasn't like a relationship. It was an on and off going, you know what I'm saying, type deal. It wasn't like an all out, like, relationship.
He says he's known Megan Boswell for about 2 months and never saw baby Evelyn.
All I've seen is pictures of her. I have no relationship with that child whatsoever.
He says he's received threats over the internet, causing him to shut down his restaurant's Facebook page.
To my knowledge, the entire time that I've known Maggie, I've never seen the baby, of course, but as well as the baby has been with the father, back from military leave. And that is all that I've known about the child.
He wants the focus to be on finding the child and not on him and his business.
There's been a bunch of stuff said about, my restaurant, Hunter T's Chicken Shack, things negative towards, to try to, stir away the main key factor of us just trying to operate.
The Sullivan County Sheriff's Office is working with the TBI to find baby Evelyn, who was reportedly last seen around December 26th.
In some aspects, the span of time that has gone by makes this a little difficult, but we are working it just as if no time has passed. Our primary our primary goal in this is to find this child.
Captain Andy Seabolt with the Sullivan County Sheriff's Office says the mother and father of the child have been cooperating with officials.
We have spoken with many family members, and I'm sure that there are some others that would be helpful if we could speak with them as well. And part of what our investigators are doing is just attempting to contact people that may have information that can assist us.
Captain Seabolt says that if anyone knows anything about this missing 15-month-old child, you are asked to contact the Sullivan County Sheriff's Office. Reporting live in Sullivan County, Febin Kassoon, News Channel 11.
Febin, thank you. And that really is the message that we will repeat over and over again until this little girl is found. They're searching for 15-month-old Evelyn Boswell, and state, federal, and local investigators tonight need your tips to help find her.
If you have any information that could help police find her, call 1-800-TBI-FIND, or you can call the Sullivan County Sheriff's Office.
So that's a good question. Do you think they met the burden? I do, if I'm being honest. I do think they met the burden on this case. My only question is sometimes, did they meet the burden like fully for her, or was anyone else involved? But she's the only one on trial, you know. So, you know, when you try and step away from it all, I do think they met their burden on the case. And I think the medical examiner, not the last one, the one before, I thought she was very good. I think she swung it for me, to be quite honest with you. I thought she's very, very good. Now it's up to the jury to decide whether she did this or if someone else did it. That is a question they'll have to answer. Do you know what I mean? So, right, there's one here. This is, let's look at this. This is Megan Boswell when she first came to court 4 years ago. Why don't you see it? Oh yeah, you don't see it, do you? I can see Katie's comments only with the last show. Oh yeah, you don't see it. For some reason, you don't see each other. I don't know why you don't see that. That's weird. So I know this is like 4 years ago, but this is her first appearance since the body of Evelyn was discovered 4 years ago. So I thought we'd play it just to see.
We'll take the state of Tennessee versus Megan Boswell, 7-2-869. That's it.
Go.
Mr. Boswell, you get to the table, I stand, raise your right hand. You solemnly swear affirm testimony about to give the truth, the whole truth, and the truth, and information you will not say is against the truth and correct.
Yes, Your Honor.
That's it. Ma'am, you're not working, you're not receiving sheriff assistance, that's
Correct.
it. You have a vehicle worth about $10,000, which you owe $7,000 on, is that correct?
I no longer have that vehicle, but I have it on it for the last 6 months.
You left the other asset questions blank, I'm gonna hand that down. If you don't own a piece of property, put a 0 or MA or something in there. You put NA on the other asset questions, ma'am, or you told me you do not own any property there.
No, sir.
I'm gonna appoint public defender, assess particular administrative fee to pay 14 days after the release. She's been bound over for a false report. There's no indictment. No, not public. That's happened. Mr. Sproles, can you take an appointment?
Yes, Judge.
The court's gonna appoint Brad Sproles.
Thank you, Your Honor.
Thank you. The case was scheduled for May 8th. The state has filed a motion to increase bond, which Mr. Sproles anticipating the appointment today, he's agreed to hear today. Is that still the case, Mr.
Judge, it is, and anticipating being appointed, I've prepared a response to that, and I've provided a copy to the state. If we could mark that file.
Of course, the other thing, it's not. We'll go forward with the motion, but another.
The judge's got a silver laptop there, not an orange one. Nice to say hello. Hello, Leslie. Back to the road errands. No worries. Love when I get the chance to. He's 18, you know, no worries at all. Adios, Leslie. Catch you later, my darling.
Issue.
And thank you again for the super chats. Thank you, my darling. Super stickers.
Is that Ms. Boswell is being held on contempt of the juvenile court, Bristol Juvenile Court.
We're aware of that, Judge.
You know, we have witnesses. Yes, sir, we do. One witness. Brian Fraley. State your name. Brian Fraley. Solemnly swear affirm testimony about to give you the truth, all truth, and the truth.
Yes, sir, I do.
State your name for the record.
Brian Fraley,
And where are you employed?
Tennessee Bureau of Investigation.
And what do you do there?
I'm a special agent criminal investigator
How long have you had that job?
since 2006.
And were you assigned to investigate the disappearance of Evelyn Boswell, assist the Sullivan County Sheriff's Office in that task?
Yes, sir.
And do you know when that investigation began?
Yes, sir, February 18th of 2020.
And how did that investigation begin?
It was originally a DCS referral that Evelyn Boswell was missing, that also went to the Sullivan County Sheriff's Department.
And did you have a date of when, according to the referral, when she'd last been seen?
As December 26th, 55 days from the time of the report.
Okay. And did you obtain the name of the mother and the legal guardian of Evelyn Boswell?
Yes, sir, we did.
And who was that?
Megan Boswell.
Is she here in the courtroom today?
Yes, sir.
Can you identify her?
Yes, sir. She's to my right here.
She was next to Mr. Sproul.
Yes, sir.
Did you determine from the referral the age of the child at the time of the disappearance?
Yes, sir.
What was that?
That was about a year.
Now, as part of the investigation, was Megan Boswell interviewed by you and other law enforcement agents during the pendency or during this investigation of the disappearance of Evelyn Boswell?
Yes, sir, she was.
And you conducted your interview one-on-one with her on, or at least you with the lead interviewer on at least one occasion?
Yes, sir, I did.
And did you review the other interviews or statements of interviews conducted by other law enforcement agents?
Yes, sir.
Ms. Boswell. Based on her responses in your investigation, did you come to the conclusion that false statements were made by Ms. Boswell?
Yes, sir, several.
And as a result, she was charged with at least one count of false report by affidavit complaint in Bristol Sessions Court. Is that
That's
correct?
correct. Yes, sir.
Okay. And what was the effect of the false statements on the investigation?
Because an Amber Alert was issued, various resources would spend man hours, time, but the most crucial thing is time lost.
And what was that?
Anytime an Amber Alert is issued, time is of the essence.
Now, these resources were not just by TBI, is that correct? Were there other agencies involved?
TBI, of course, all Sullivan County Sheriff's Department, criminal investigation team, FBI was brought in, dozens of agents and investigators.
So I want to go to March 6th this year. And was there a search conducted at the residence of the Boswell family on that date?
Yes, sir, there was.
And when I say Boswell family, we're talking about the defendant's father, brother, and grandmother. Is that correct?
That's correct, yes, sir.
And what was found upon that, conducting that search?
There was a body, a child, approximately a year
year and a half old.
Even though it's not been positively identified by forensic testing, did that child appear to be the same age, same size as the photographs and the information you obtained even from the defendant about the child's characteristics?
Yes, sir.
What else was found there?
The clothing with the prior interview of Ms. Boswell, clothing described in that interview was exact clothing that was found on this child.
What else was found there?
There was various child clothing, diapers, toys, that kind of thing that would belong to the child.
Based on your conversations and observations of the defendant during the investigation, did she have does she currently have did she then have a residence? Did she have a place where she lived and stayed?
No, sir, she did not.
Is she currently employed?
No, sir.
Would she be able to go back to where she was working before while this investigation was pending?
Most likely not.
Okay. Were you aware of any out of state and out of contacts during the relevant dates in this investigation the defendant has with other individuals?
Through the investigation, we identified 3 states, Virginia, North Carolina, and Texas.
Her mother drove to North Carolina, is that correct?
That's correct.
And the mother's boyfriend, Mr. McLeod. And did you also determine that the defendant had made trips out of state?
Yes, sir.
And where was that?
Texas.
And when was that time period?
The fall of 2019.
Also, were there trips out of town made outside the Tri-Cities?
Yes, sir.
Where was that?
Knoxville, Gatlinburg, Sevier County.
That's all the questions we have this time. Agent Fraley, you were describing trips outside of Sullivan County. You said Texas. Do you know when that trip occurred?
I believe it was October 2019.
Okay. Prior to the events here?
Yes, sir. Prior.
And then you described trips to Knoxville or Gatlinburg.
Yes, sir.
Do you know when those occurred?
I don't have the exact dates. I don't recall those.
Okay. Can you say since the investigation has been ongoing that she's been out of state?
To my knowledge, she is.
And then during your investigation, did you have a chance to look at the criminal background or any prior convictions from Ms. Boswell?
Yes, sir.
And what did you find?
No criminal history.
Okay. She's never been convicted. And did you see that she never been charged with any kind of failure to appear?
That's correct.
Okay. You described that she has some contacts out of state. Does she also have contacts here in Sullivan County, family membership?
Yes, sir, she does.
Okay. Could you say that the majority of her family contacts and relationships are here in Sullivan County?
Yes, sir.
That's all the questions we have. This one, dependency investigation, she was in Virginia, is that correct?
I'm sorry.
She was in Virginia, the defendant, during the time of the investigation of disappearance. She did go into Bristol, Virginia.
Yes, that's correct.
That's all. No further. No problem.
Agent Fraley, during your investigation, did Ms. Boswell make any exculpatory statements with regard to the death of Evelyn Boswell?
You say culpatory or culpatory? Yes.
I've asked the question. Do either parties have a question? No, not this time. Any other proof?
No, you're all right with the state.
Any proof, Mr. Stokes? No, Judge.
while the court is aware from the truth today that Ms. Boswell does not have prior criminal history, does not have a history of failing to appear for court appearances, has family ties in the Sullivan County area. The truth also is that she has ties to Virginia and ties to Texas, at least that she's gone to those two states. I'm not nearly as concerned with the fact that she's gone to Knoxville, Sevier County. I am concerned that she has, especially ties to Texas. The court's also considered that during the pendency of an investigation, Ms. Boswell has made incorporated statements with regard to the death. And when I weigh the positive and negative factors that we have to consider for bond, length of residency, employment. Truth was that she's not working now, which is partially that she wouldn't be able to go back to that same job in the option opinion. We discussed family ties and relationships, reputation, character, mental condition. I think that's going to be a negative factor given the statements that she's made, implicating herself in the child's death. She has no prior criminal history. Nature of the offense is here is false statement that is regarding and surrounding the disappearance of what we believe would be ultimately the death of the child. From listening to the proof and reading the affidavit, the probability of conviction for the false statement seems to be high. She has no criminal record. No one's testified here today that members of the community who vouched for her. Weighing the positive and negative factors, courts have the opinion the bond should be increased. It'd be increased to $150,000. Now, General, when's this case going to go? Probably April. We have a date. Next grand jury, I think, is next week. I don't think we'll be ready then, but I think we will be ready to present the case and some other related false reports. We intend to submit those in April. I'll have to put it on May the 8th. That's what it was originally. That's the Bible today. That's fine. May the 8th.
Okay, so let me just check the other one now. Where we are. So, whilst we be doing that, I'd be planning, because that's the way right. Let me have a look here. Where is it? There. So let's plan, baby, plan, baby, plan. Oh, plan, baby, plan, baby, plan. They're still on break in that trial. On the other one, sorry. So my plan is this, right? I'm just waiting for Erin Hack to respond because obviously she has to tell me what I've got to do and stuff. She's my boss. But my plan is this. They'll be back at 10:30, 10, 11, 12, 1, 2, 3. So they're supposed to be back now. They're not back though. So, do we wait for court to come back, which, we might have to, or do we zoom it? So I want to Only when Sarah isn't here, yes. Sarah is my main boss. Hey, Keith. So what I want to do, there's two things I want to play, right? Myself, I'll look at this now, hang on. Boom, boom. I want to play a hour and a half stream from yesterday, which is the Georgia school shooting, Georgia v. Colin Gray. I'm interested in it, so I want to play that. And also, I want to start a new trial. But also, we've got these jury instructions and we've got the closing arguments. So I could play the shooting stuff now for an hour and a half, then zoom the closings and all that, or wait for the closings and all that to finish, whenever that will be, and then play the Colin Gray stuff and look into the new trial. I know that the ladies all love a zoom. They like it to be over sooner rather than later. Also, are people interested in the jury instructions? Because the jury instructions could be like probably hour and a half, 2 hours. Colin stuff. There you go. That's all I needed. Zoom. Colin Gray. Fine. So we'll do that. We'll do that then. We'll do that. And then we'll go back to the other one then after that then. So let me put a note here now because some people will be pissed off. Watching GA v. Colin Gray hearing. Will cover Megan closing. Okay. So there's that. So I can put that on. The other thing is the trial I'm looking at is gonna be a trial called where is it? Hang on, let me find this first. It's the it's already started, but I think that's fine though. It's the mofo. Can't find it now. No, it's not that one. Oh, where is it gone? Let me find it and then I'll tell you what it is. Where is it? I'm trying to find the frigging thing. Right, hang on. It's here somewhere. Let me go to Lawn Cry. It is the Twisted Secrets murder trial. Zachary Hughes, South Carolina versus Zachary Hughes. They're on day 2 right now, so we'll do that. Oh fuck, quarterback. So what we? Oh, hang on. So what we do with Mexi? Let me hear what the judge has to say first, and then we'll do that. Let me hear. I just got 2 tabs fucking open now. Hang on. No, I don't want that open. I know, Robin. I'll zoom in like anything. I love a zoom. Everybody say zoom. But what I want to do is hear the court to see how much they are going to give for closings and stuff. You see, this is what I get. I get bitchy Mexi now. That's the problem now. I love Mexi, but she hates me sometimes. Let me hear if they say how much time they're going to have for closings. I don't think they will say anything, will they?
Or the charge in its final form. General is written.
Yes, sir.
All right. Which is long. Judgment forms. I would tired of the jury. If the
On his desk, he's describing the status of the prize rating.
And I won't say it, I'm sure I won't think to say it, but the presentment is required to go back with the jury charge.
And was that redacted out?
Defense ready to proceed.
Yes, Judge.
Then let's bring the jury in.
Okay, well, I think we're a bit stuck now, are we? Okay, so I think we just stick with this then, should we? Because they're ready, so...
Everyone stand, please.
And then we'll do the calling one after this. I didn't realise it would go straight into it. So we'll do that, and we'll call in Grace straight after this then. Whilst they're deliberating, so...
You may be seated. Thank you.
All right. All right. In the criminal court for Sullivan County, Tennessee, at Blumble, State of Tennessee versus Megan Boswell, defendant, case number S72 of a corpse. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Jury instructions. Members of the jury. Count 1 of the presentment charges the defendant, Megan Boswell, with the offense of premeditated first-degree murder. This offense embraces the lesser-included offenses of facilitation of premeditated first-degree murder, attempt to commit premeditated first-degree murder, facilitation of attempt to commit premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, child neglect, attempt to commit child abuse, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 2 of the presentment charges the defendant, Megan Boswell, with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offenses of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, attempt to commit child abuse, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 3 of the presentment charges the defendant, Megan Boswell, with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offense of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child neglect, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 4, the presentment charges the defendant, Megan Boswell, with the offense of aggravated child abuse. This offense embraces the lesser included offenses of facilitation of aggravated child abuse, attempt to commit aggravated child abuse, facilitation of attempt to commit aggravated child abuse, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child abuse, attempt to commit child abuse, assault, and attempt to commit assault. Count 5 of the presentment charges the defendant, Megan Boswell, with the offense of aggravated child neglect. This offense embraces the lesser included offense of facilitation of aggravated child neglect, attempt to commit aggravated child neglect, facilitation of attempt to commit aggravated child neglect, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child neglect, attempt to commit child neglect, assault, attempt to commit assault. Count 6 of the presentment charges the defendant, Megan Boswell, with the offense of tampering with evidence. This offense embraces the lesser included offense of facilitation of tampering with evidence, attempt to commit tampering with evidence, and facilitation of attempt to commit tampering with evidence. Count 7 through 17 of the presentment charges the defendant, with Megan Boswell, with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant, Megan Boswell, with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant, Megan Boswell, with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense. Count 2, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. And 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. The killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. And 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the aggravated child neglect, the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And 3, excuse me, 3, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally had previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you will so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown or established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix a fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has previously been defined for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of these instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of criminally negligent homicide is charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix a fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another. And 2, that the act resulted in serious bodily injury. For purposes of this count, intentionally, knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have a reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another. And 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than not greater than $5,000. and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5. Misdemeanor reckless endangerment. Any person who commits the offense of misdemeanor reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of misdemeanor reckless endangerment as charged in the presentment, then your verdict must be not guilty as to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. That should say neglect. All right, let me reread that. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew an investigation was in progress, and 2, that the defendant concealed a thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, knew, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of tampering with evidence as charged in the presentment, then your verdict must be not guilty as to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officer is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the statement was made by the defendant. 2, that statement was made in response to a legitimate inquiry by a law enforcement officer. And 3, that the statement would concern a material fact about an incident within the officer's concern. And 4, that the defendant knew such statement was false. And 5, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur. For purposes of this count, new and law enforcement officer are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false report, then you may fix the fine in any amount not greater than $5,000, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt in a false report as charged in the presentment, then your verdict must be not guilty as to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of abuse of a corpse, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of a corpse as charged in the presentment, then your verdict must be not guilty as to this offense. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly failed to report the death of Evelyn Boswell to the county medical examiner, local police, district attorney, or sheriff. And 2, that the death was from violence, trauma, or any suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under circumstances as the defendant believed them to be at the time. And his actions constituted a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2, attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3, attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4, attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5, attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count 6, attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. Attempt to commit false report, maximum fine $5,000. Count 19, attempt to commit abuse of corpse, maximum fine $2,500. Count 20, attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1, facilitation of first-degree murder, maximum fine $50,000. Facilitation of attempt to commit first-degree murder, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6, facilitation of tampering with evidence, maximum fine $5,000. Facilitation of attempt to commit tampering with evidence, maximum fine $3,000. Count 19, facilitation of abuse of the corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense are circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or new means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Recklessly or reckless means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Child neglect. 19. Attempt to commit child abuse. 20. Attempt to commit child neglect. 21. Assault. 22. Attempt to commit assault. 23. Misdemeanor reckless endangerment. Count 2. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Attempt to commit child abuse. 19. Assault. 20. Attempt to commit assault. 21. Misdemeanor reckless endangerment. Count 3. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17, child neglect. 18, attempt to commit child neglect. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 4, 1, aggravated child abuse. 2, facilitation of aggravated child abuse. 3, attempt to commit aggravated child abuse. 4, facilitation of attempt to commit aggravated child abuse. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child abuse. 15, attempt to commit child abuse. Count 5, 1, aggravated child neglect. 2, facilitation of aggravated child neglect. 3, attempt to commit aggravated child neglect. 4, facilitation of attempt to commit aggravated child neglect. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child neglect. 15, attempt to commit child neglect. Count 6, 1, tampering with evidence. 2, facilitation of tampering with evidence. 3, attempt to commit tampering with evidence. 4, facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. 1, false report. 2, attempt to commit false report. Count 19, 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20, 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond a reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second?
I switched off. I was sleeping. I had no idea what's happening. Fuck, I dozed off again. Jeepers, come on. There's been a lot of typos, Maxie. He just amends them as we go along. I have no idea if he's done or not. This is why it could take forever. I'm moving my legs. You can't see it, but I'm moving my legs up and down. And I will take a little bit of a break after all this as well. But I appreciate you, Robin. Oh. I think he's just making an amendment to it. I know, I'm just too tired at the minute with this guy. It's like they loaded up the charges. Like if they could have found guilty with him, maybe they could find guilty on a bunch of lessers. Yeah. I know. My legs are moving like anything right now. I'm just, honestly, this is like me. This is what I go through. Sleep apnea is a bitch, guys. What I want to do now is sleep. Ugh. Head bobbing like this, Keith. Not the one that you thinking of.
All right. Now, ladies and gentlemen, remember, when you go back there and you select a four-person, this is the official jury charge, okay? And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment in a separate sentencing hearing. You'll be provided with forms for all possible verdicts in this case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. Now, in your books, you don't have, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of first-degree murder. Or checkbox 2, guilty of facilitation of first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 4, guilty of guilty of facilitation of attempt to commit first-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder. Fine amount $ blank, not more than $25,000. Verdict form, count 1 continued. Checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $ blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $ blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter, find amount dollar sign blank, not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, find amount dollar sign blank, not more than $5,000, or checkbox 14, guilty of facilitation of reckless homicide, find amount dollar sign blank, not more than $3,000. Excuse me. Or verdict form count 1 continued, checkbox 15, guilty of criminally negligent homicide, find amount dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, find amount dollar sign blank, not more than $2,500, or checkbox 17, guilty of child abuse, find amount dollar sign blank, not more than $2,500, or checkbox 18, guilty of child neglect, find amount dollar sign blank, not more than $2,500, or checkbox 19, guilty of attempt to commit child abuse, find amount dollar sign blank, not more than $500, or checkbox 20, guilty of attempt to commit child neglect, find amount dollar sign blank, not more than $500, or checkbox 21, guilty of assault, find amount dollar sign blank, not more than $2,500, or checkbox 22, guilty of attempt to commit assault, find an amount of dollar sign blank, not more than $500, or verdict form count 1 continued, checkbox 23, guilty of misdemeanor reckless endangerment, find amount dollar sign blank, not more than $2,500, or checkbox 24, not guilty, 4-person signature line date blank. Verdict form count 2, with jury find the defendant Megan Boswell marked appropriate 1, checkbox 1, guilty of first-degree murder in the perpetration of a felony, or checkbox 2, guilty of facilitation of first-degree murder in the perpetration of a felony, find amount dollar sign blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first-degree murder in the perpetration of a felony, find amount dollar sign blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first-degree murder in the perpetration of a felony, find amount dollar sign blank, not more than $25,000, or checkbox 5, guilty of second-degree murder, find amount dollar sign blank, not more than $50,000, or verdict form count 2 continued, checkbox 6, guilty of facilitation of second-degree murder, find amount dollar sign blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second-degree murder, find amount dollar sign blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second-degree murder, find amount dollar sign blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, find amount dollar sign blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, find amount dollar sign blank, not more than $5,000. Checkbox 11, guilty of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, find amount dollar sign blank, not more than $5,000, or verdict form count 2 continued. Checkbox 14, guilty of facilitation of reckless homicide, find amount dollar sign blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, find amount dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, find amount dollar sign blank, not more than $2,500, or checkbox 17, guilty of child abuse, find amount dollar sign blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child abuse, find amount dollar sign blank, not more than $500, or checkbox 19, guilty of assault, find amount dollar sign blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault, find amount dollar sign blank, not more than $500, or verdict form count 2 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, find amount dollar sign blank, not more than $2,500, or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 3. We, the jury, find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of first-degree murder and perpetration of a felony, or checkbox 2, guilty of facilitation of first-degree murder and perpetration of a felony. Find amount dollar sign blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first-degree murder and perpetration of a felony. Find amount dollar sign blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first-degree murder in the perpetration of a felony. Find amount dollar sign blank, not more than $25,000, or checkbox 5, guilty of second-degree murder. Find amount dollar sign blank, not more than $50,000, or Verdict form count 3 continued. Checkbox 6, guilty of facilitation of second-degree murder. Fine amount $, blank, not more than $25,000. Or checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $, blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $, blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $, blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $, blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount $, blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount $, blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount $, blank, not more than $5,000. Or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide. Fine amount $, blank, not more than $3,000. Or checkbox 15, guilty of criminally negligent homicide. Fine amount $, blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount $, blank, not more than $2,500. Or checkbox 17, guilty of child neglect. Fine amount $, blank, not more than $2,500. Or checkbox 18, guilty of attempt to commit child neglect. Fine amount $, blank, not more than $500. Or checkbox 19, guilty of assault. Fine amount $, blank, not more than $2,500. Or checkbox 20, guilty of attempt to commit assault. Fine amount $, blank, not more than $500. Or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment. Fine amount $, blank, not more than $2,500. Or checkbox 22, not guilty, 4-person signature line date blank. Verdict form count 4, we the jury find the defendant Megan Boswell mark appropriate one. Checkbox 1, guilty of aggravated child abuse. Fine amount $, blank, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated child abuse. Fine amount $, blank, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child abuse. Fine amount $, blank, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child abuse. Fine amount $, blank, not more than $10,000. Or checkbox 5, guilty of aggravated assault, fine amount $, blank, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault. Fine amount $, blank, not more than $5,000. Or verdict form count 4 continued. Checkbox 7, guilty of attempt to commit aggravated assault. Fine amount $, blank, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit aggravated assault. Fine amount $, blank, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault. Fine amount $, blank, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault. Fine amount $, blank, not more than $3,000. Or checkbox 11, guilty of assault. Fine amount $, blank, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault. Fine amount $, blank, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment. Fine amount $, blank, not more than $2,500. Or checkbox 14, guilty of child abuse. Fine amount $, blank, not more than $2,500. Or verdict form count 4 continued. Checkbox 15, guilty of attempt to commit child abuse. Fine amount $, blank, not more than $500. Or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 5, we the jury find the defendant Megan Boswell mark the appropriate one. Checkbox 1, guilty of aggravated child neglect. Fine amount $, blank, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated neglect. Fine amount $, blank, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child neglect. Fine amount $, blank, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect. Fine amount $, blank, not more than $10,000. Or checkbox 5, guilty of aggravated assault. Fine amount $, blank, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault. Fine amount $, blank, not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault. Fine amount $, blank, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault. Fine amount $, blank, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault. Fine in the amount $, blank, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault. Fine amount $, blank, not more than $3,000. Or checkbox number 11, guilty of assault. Fine in the amount $, blank, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault, fine amount $blank, not more than 500, or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount $blank, not more than 2,500, or checkbox 14, guilty of child neglect, fine amount $blank, not more than 2,500, or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect, fine amount $blank, not more than 500, or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 6, we, the jury, find the defendant Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of tampering with evidence, fine amount $blank, not more than $10,000, or checkbox 2, guilty of facilitation of tampering with evidence, checkbox the amount $blank, not more than 5,000, or checkbox 3, guilty of attempt to commit tampering with evidence, fine amount $blank, not more than 5,000, or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence, fine amount $blank, not more than 3,000, or checkbox 5, not guilty, 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of false report, fine amount $blank, not more than 5,000, or checkbox 2, guilty of attempt to commit false report, fine amount $blank, not more than 3,000, or checkbox 3, not guilty, 4-person signature line date blank. Verdict form count 19, we, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of abuse of a corpse, fine amount $blank, not more than $3,000, or checkbox 2, guilty of facilitation of abuse of a corpse, fine amount $blank, not more than $2,500, or checkbox 3, guilty of attempt to abuse a corpse, fine amount $blank, not more than $2,500, or checkbox 4, guilty of facilitation of attempt to commit abuse of a corpse, fine amount $blank, not more than 500, or checkbox 5, not guilty, 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, fine amount $blank, not more than 3,000, or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances, fine amount $blank, not more than 2,500, or checkbox 3, not guilty, 4-person signature line date blank. Back on page 48. You'll be provided with, well, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. I'm going to stop right there. Is there lunch here? Your lunch is here. I'm going to let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm going to have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge.
Everyone stand, please.
Fucking hell. Hey, enjoy your work. Enjoy your walk. Dennis, enjoy it. Right, let's see if he comes back. Did he finish? Or did he, like... I don't know, got a clue what the hell's going on anymore. I was napping. Right. I need a break. At what time are they coming back? Oh, fuck, hang on, let me go back then. What time are they coming back?
You take your lunch here. Your lunch is here. I'm gonna let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm gonna have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge. Everyone stand, please.
I don't want to play the other video, Lady Di, because I'll tell you why. Because I need it a little bit for the deliberations as well. That's my issue with it. If I play it now, then I want to watch it, if that makes sense. But if I watch it, I can't have a break. He didn't say how long though, because I do want to watch that myself, and I need to have a break as well. Otherwise, I'm going to be fucked. So I think what I'll do is, I think what we'll do is come back in an hour. You're right, Hippie Chick. So what I'm going to do is close this one down, redirect you to the other one, and I'll come back at quarter past one. Then we'll listen to closings, and then what we'll do is watch the call-in one and stuff like that then as well. Because I do want to watch it. I don't want to miss out on it, but I need to go and get some lunch as well. So that's what we'll do. Thank you for that. Right. So let me close this, and I'll see you all in a little bit on the other one. You can still go over the chat. I won't be live for an hour. Thank you. Love you, most of you. No, love you all. Take a bit. Ta-ra.